Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. Good evening. My name is Pam Esquire, also known as Your Law Intellect. Welcome, welcome, welcome to everyone that is new. If you have not done so already and you like it over here, please commit and subscribe to the channel. Please make sure you like the video so that we can get into the algorithm. I was just over here watching this debate with Trump and Biden. I feel a little better, but at first I was like, oh no, I'm still voting for Biden though, but I'm just saying. He was standing up there looking like, I'm like, is he going to talk? Is he going to freeze? He was trying to get his words together. He was just really looking so unwell, like, I just can't believe back in the day, they would really train people up like a young politician in order to make sure they take that position. But we really don't even have anybody. But listening to his conversation, once he can get his thoughts out, he made sense. Now, the problem was Trump is over here making stuff up, but he's saying it with his chest. You know what I'm saying? He's up there like, and I'm the best president that ever lived. You can look at every polls. You can look at everybody. They say that I'm the best president. You were the worst president ever. Everything was great under me. Everything. Oh, don't worry. All my convictions are going to be overturned. Like he was saying it with confidence, And so, see, President Biden is just a little elderly now. I mean, he's like 81. And so his voice projection is weak. And then he looks a little like dazed. It's just a lot going on. But it was a couple of comments when Biden started getting a little pissed. That's what I was saying. Like, Biden, you need to get pissed. Biden, you need to get pissed. So he started getting mad and he was making little comments like when he started talking about, I think he was prepared that they were going to talk about his son being convicted. So he was already ready for the comeback. Like, you talking about the person that, doing this woman and you slept with a star? Yeah, you have the morals of an alley cat. Then Biden was like looking at him while Trump was talking. He was just looking like, and he looked like he wasn't paying attention. And I didn't know what his response was going to be. Then he said, yeah, I don't even know where the hell he's been. I was like, okay, Biden, he getting a little snippy, But what I don't like about like CNN or any of them, they're not fact checking anything. So all this shenanigans that Trump is talking, it sounds accurate. Like he is saying it with a level of boldness and confidence that if you really have not paid attention, don't know what's going on, you really will believe him. And it's had my nerves bad. Just had my nerves bad. But anyway, that is just my intro as to why I was a little late. Look, I'm almost finished. There's about 15 minutes left in this debate. Then Trump says, this guy lies so much. I've never met anybody that just lies as much as he does. I mean, look you right in the eye and just lies. Trump, is that you? He said it like with confidence. I've never met anyone in my life that just lies as much as Joe Biden does. After he's told probably about 15 lies while he was standing on it. I said, what has this world come to? What? Then it was already an issue with CNN because apparently they didn't allow credentialed Black people to be there. And so people are calling them out because they tried to say they didn't meet the deadline. So people are calling them out to prove it. So we were already pissed with CNN. But these moderators not fact checking with anything. You got these questions. You should basically know the posture of what they're talking about with the economy and all of that. And just letting them say whatever and be like, okay, next. It's like they're more concerned about staying on time. So nobody is and taking control, because I think that's been an issue when Trump is up there, that they feel like they let it go all over the place. But Trump is actually kind of calm. I don't know if he had a gummy or something before he got up on there. I don't know if he had some nice smooth tea, the nighttime sleepy tea, but he kind of calm. Now he's making a bunch of faces. You guys talk about my faces. Trump is on there like, but that's my recap. I'll probably look later to see the fact checking. But anyway. Yes, welcome to all of the intellects. Make sure you guys hit that like button on the way. Abundant and Clarity said he had me cracking up. They are both. That's what I'm saying. Biden got some really good comebacks. You know what I'm saying? Like, he got some good comebacks and he can support and stuff. But the problem is he's not saying it with like he's just seems so weak that it just doesn't come across like that. Like, I don't know if he should have had something on his lapel to like hype the mic up so he can sound louder than what he was. But it's like Trump will stand up there and just be loud and wrong. Like, everyone says you are the worst president in American history. Like, he says it where if you're not paying attention, you really believe that that's what everybody is saying, because he's saying with such confidence and he's projecting it. Then you got Biden, who just, you don't know if he's going to be able to get his thoughts out, because that's when you have a speech impediment, especially with stuttering, you have to say, like, slow down, slow down your thought process. And the problem is Trump is probably saying things that aren't accurate, that it's pissing Biden off. And so he has so many things going in his head. So now you got to calm down, because it's going to come out like it's going to come out like that because you're trying to get your thoughts together, because you got so much stuff going on. And that's the thing with stuttering. Like, you have to slow it down. And with Trump, he probably just want to get on it. Then they give you that certain amount of time that you have to respond within a certain amount of time. They give you 5 minutes and all of that. Yeah, that thing just stressed me out. I started to stream it too, but then I was like, yeah, no. I don't know what they might say on this. And then they, I have that problem I had with the judge when I played that video, and they was like, YouTube was like, no, it's too much profanity. So, what y'all saying? Georgia P said, do you think Young Thug is going to go home with time served? I don't think so, but I mean, let's get into it. I haven't followed the case like that. I think from what it's all over the place, so anything is possible. When you say go home with time served, that means that he pleads to something or he's convicted of something. And then it's like the Erica situation, of which they gave her a time of incarceration, but then because she had done almost a year, they gave her a year credit. So you're saying in order for this, what you're asking to even take place, that wouldn't even have anything to do with them trying to do mistrials and throw things out, right? It wouldn't have anything to do with that. He would literally have to plead to something, or he would have to win at trial and then get sentenced, and then they do time served. So that's why I made that comment. Do I think the case is all over the place? Absolutely it is, as we will be going over in a few minutes. So what we are here for today, we weren't here for the Trump debate. I post every now and then things that has to do with the YSL trial. I don't cover it on a daily basis. If something that I can isolate and talk about, such as what I'm going to do tonight, then I will do that, because the case is literally been going on they started jury selection about a year ago, and that's technically the start of the trial. So the trial has been going on for a long time. Right now, they're on hiatus to like July 7th or 8th or something, because they're trying to figure out allowing interview clip to come out, the interview of Woody to come out. And so now it's objections. It's, do we got to delete part of it? What is admissible? What's not? So they're dealing with admissibility. But for those of you that have been following the case, you probably know a whole lot more than me. But what I will say is, this situation now of them trying to get this judge off the bench is just, it sounds like all the defendants pretty much are on board of who it affects, and they trying to get Judge Glanville up out of here. So about a week ago, there was a motion that was filed, and I'm going to read part of that motion, because some of you guys may not know about the quote secret meeting and the show cause, because I put the documents on my page, on my wall, community wall. But again, I don't really discuss the case. So we're going to go over it together. This is just one aspect of the case. For those of you that don't know, what the trial is about is, the Fulton County prosecutors are basically saying that Jeffrey Williams, aka Young Thug, is the head of a GAN affiliate, add the last letter, affiliated organization called Young Slime Life, I think is what it is. Yeah, Young Slime Life. And they're saying it formed around 2012, and through this power structure that they have created, it's alleged that they have committed armed robberies and carjackings and narcotics and shootings and unaliving folks and all of this. I mean, like a crime spree from 2012 until they were arrested. And they're supposed to be an affiliate of a larger, criminal or, organization. So they're charged with the RICO. And if you guys have watched it, I honestly thought about following it, but it was one hearing with a motion, and I know DA Love was actually arguing, and I remember it like yesterday. The judge ruled against her, and she kept standing up and was like, "But judge, da da da," and kept talking. He's like, "Madam, I made my ruling. Sit down." And she kept talking. And I was like, so you just gonna let her take over this whole courtroom? She talked probably 35 minutes, not exaggerating, past the judge consistently telling her, "I made my ruling, sit down." I knew from that point on, this case was going to be a whole entire mess, because there was no control. It didn't seem to be control over the courtroom. So what ended up happening was, apparently there is a witness who was on the stand. The first day, his name is Woody. He ended up getting held in contempt because he didn't want to testify. And judge was like, "Listen, you have immunity. So because you have immunity, you saying you're not going to talk is not going to work." So he gets on the stand and he was like, she said, "How old are you?" He was like, "Grown." What does grown mean? I can't say that DA, she keeps her composure, because how old are you? That's how I would have been. We would have been going back and forth with the how old are you. Know exactly what I'm talking about. Like, cut it out. But she was just like, "What does grown mean?" So he basically started being very combative and non-compliant as soon as he hit the stand, which has been the tenure of it. It's been the posture of most of the people that have been on the stand for the state. Okay. Aside from, of course, the cops and investigators and all of that. So apparently, when he did his weekend up there on Rice Street, he probably came back a whole different person, because you guys heard them talking about Rice Street. and how terrible the jails are. And they got flooding and you're sleeping on floors and you got, something going on with the toilets and the food's all jacked up and all of that. And it's dank. People have been unalived up in that piece. You had one guy who had the bed bugs that ate him alive. We've all heard all of this horrible stuff. So he did a cool weekend, right? And then he came back, and apparently there was a secret meeting. It was ex parte because it was one-sided. The defense, all those defendants, none of their defendants or the defense attorneys knew about this meeting. And so when the meeting occurred, it was, according to the attorney that represented Woody, who was there, Miss Bumpus, I think is her name. She was there. It was probably about 14 people, according to her, on the interview I saw that was actually in this meeting. But none of those 14 people consisted of the defense team. So Mr. Steele, who represents Young Thug and probably is getting paid very, very well, he got up there and he let the court know, I know about this meeting, and that's a problem. And so he ended up getting thrown in jail and then getting held in contempt. You know why he got held in contempt? Let me tell you. He got held in contempt because the judge said, who told you about this ex parte meeting? Who gave you this information about this ex parte meeting? And he forgot all about, like, should the ex parte meeting had even happened in the first place? He seemed like he was fine with it being an ex parte meeting. His issue was somebody told them, and I don't know if he told the people in there, don't let nobody know this meeting happened. I don't know if that's why he was mad about it, but still said, I'm not telling you that. And he stood right there boldly and said, I'm not telling you nothing. I'm not telling you that. And so next thing you know, he's asking the judge, well, judge, since you said I have to do 20 days, because that's what the judge gave him, held him in contempt because he refused to say who told him. He said, well, can I kick it with my client on the weekend? Because we talk all the time, and I'm going to need to be able to prepare for my case. So he would have been doing it on the weekend, except, he still would have been represented, Mr. Williams, Monday through Friday. Judge agreed. So once he was held in contempt, the Georgia Defense Bar Associate, all of them came. Okay, they were all up in the hallways trying to come to his rescue. Had about 2-3 law firms, including his law firm, which his wife is in, and then also Miss Merchant, which a lot of you guys know is the one that was coming off of coming after Madam D.A. Fonnie Willis on this whole situation with her relationship with Nathan Wade. So everybody's trying to get this judge to recuse himself for various reasons. They were doing that throughout the trial because they felt like it was biased. I know it was one point in front of the jury, which was improper in my opinion. The judge sat in front of the jury and basically talked about Steele in a negative fashion, which you're not supposed to do. So there's been a lot of issues that they've had where they filed motions for mistrials, motions for him to recuse himself, just a lot of back and forth going on. Well, a week ago, it hit the news of which, well, if you guys watch, because I think I did some commentary on this portion. If you guys watch, Steele didn't have to do any time. They immediately went to the Court of Appeals. The Court of Appeals immediately granted him a bond. So he didn't have to do any time at all. And then the judge ordered a show cause hearing that all the people that was present, including the security, they had to show cause why they should not be held in contempt for telling about the secret meeting. Again, the underlying problem to me was that the meeting happened, but apparently not for the judge. So Bumpus ended up lawyering up because I seen about two or three different attorneys that put in an appearance for her because she was the one that was representing Woody. She said she was just doing it as a limited, she was covering for somebody else, and she had represented him in the past, I guess. So it was already determined that she was just going to do it for this one time, and she wasn't his attorney. But the judge acted like Judge Glanville was acting like he wasn't going to let her out. But apparently he was waiting probably to type up that order to show cause, like, you'll be back because you're about to come too. And we're going to figure out who told Steele that we even had this meeting in the first place. So the issue came where the defense attorney, Steele, and for, I think his name is Doug Weinstein, he was actually on the Y&W Melly case trial too. We streamed that over here about a year ago. That ended up in a mistrial. But Weinstein filed a motion to recuse the judge because they're saying that, how are you going to be over these hearings? And the hearings are about you. So how you going to be over these hearings? So of course he denied. He was the one over the recusal hearing, said he denied his motion to kick him off the bench, which, I mean, is that a shocker? And then they don't want him to be over the show cause hearing on the contempt. They say you shouldn't be over it pursuant to law. He was like, no, you wrong. And so Weinstein, on behalf of his client, filed a motion, an emergency motion with the Georgia Supreme Court. So this is the motion that he filed, and it was about a week ago. So, and he represents Diamante Kendrick, as you see, is versus Chief Judge Glanville. And it's a lot because you guys see they got to do a table of contents here. But it is the Supreme Court. You got to come correct when you come into the Supreme Court. So he said, this emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioners' state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville and not to any rulings or orders of the judge. This court has jurisdiction over this matter under the Constitution, and it has all of those numbers. In the case at bar, original relief in the form of motions for recusal have been filed and denied 3 times by 3 respective movements. So 3 of the different defendants have already tried to recuse him, and he told them no. Likewise, Glanville has denied the movement's respective requests for a certificate of immediate review 3 times. Glanville, as chief judge, has obstructed defense counsel's attempts to have a disinterested party review the numerous allegations contained in at least 4 affidavits which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. Citing a lack of evidentiary foundation caused by Glanville's own recalcitrance, and refusing to provide a transcript of a secret ex parte proceeding, Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificate of immediate review. Assuming this court would not get the opportunity to review the decisions on the multiple motions to recuse unless or until the underlying case was concluded, Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight for abuse of discretion. So basically, Glanville's been saying, well, once we finish the trial, you can file whatever you guys want to file in your appellate review. And then in appellate review, whatever the lower court, which is what he is, the trial court decides, there's going to be an abuse of discretion, which is a very high standard when you try to come against a judge's decision. Glanville's obstruction of defendants' right to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. 3 motions for recusal have been filed and denied, and 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than about 1 year. So they've had petitions before that have been filed in front of the Supreme Court. So one of the petitions that they've already filed about a year ago, there was a petition for a writ of mandamus to order return of seized property related to property seized during the arrest of Mr. Williams or Young Thug, was filed by claimant Raffaello and Company, Inc. on July 24, 2023. It outlines lack of action by Chief Judge Glanville over the course of the time dating back to June 17, 2022. The petition for writ has yet to be shared by Chief Judge Glanville, and claimant has not agreed to any delay in the hearing of its petition. In the meantime, claimant is without over $1 million in their property loaned to Mr. Williams for his performances. So apparently they must have seized some property that belonged to, when they arrested him, that, you know, a lot of these celebrities, they rent some of this stuff, some of this jewelry or whatever they get, and it's loaned out to them. And so they're supposed to return it. Well, apparently it got taken when he was arrested and they have not returned it. So the company has filed a petition to get it back and they haven't heard anything. It's been crickets. An additional petition for writ of mandamus seeking similar relief on these facts was filed on October 24th of 2023 and has also yet to be heard by Chief Judge Glanville, despite efforts by claimant's counsel to have a hearing on the matter. So those are the two writs that they're saying was filed, and basically the judge has done nothing. Therefore, any effort to file a writ in Fulton County that would be heard by Chief Judge Glanville will result in frustration and lack of action. Glanville's court is where writs go to die. Basically, he's saying, we need your help, Georgia Supreme Court, because if we file anything up in Fulton County and he's the chief judge, the writs they're just going to sit there. They're just going to sit there and they're not going to be heard. So we need the courts to step in. He said that's where they go to die. That is crazy. As the present petition for writ of mandamus would go to Glanville if filed in Fulton County Superior Court, petitioner has no option other than for Georgia Supreme Court to exercise its discretion and consider defendant's claims. A secret ex parte proceeding was held on June 10th, 2024. In attendance were Glanville, sworn witness Kenneth Copeland, that's Woody, prosecutor Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County Sheriff's Office. As a result of the proceeding, on June 12, 2024, petitioner requested that the presiding Judge Glanville recuse himself from petitioner's trial for, among other counts, count 2, which is unaliving someone under OCGA section 16-5-1. Despite preceding all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedures of USCR 25.3. Glanville denied a request for a certificate of immediate review. A formal order denying the motion was entered on June 14th of 2024, 2 days after a motion for recusal was filed. So he's saying we filed the recusal and 2 days later he had already just dismissed it and denied it. As chief judge of the Fulton County Superior Court, Glanville holds a unique position within the county, which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that will permit the Georgia Court of Appeals to review his decision on the recusal motion. Therefore, invoking the original jurisdiction of this court to issue writ is petitioner's only recourse. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. The appellate procedure in this case, the bar will be extremely lengthy and cumbersome with more than a year's worth of transcripts to review. Yeah, that's going to be a mess. When they go through the appellate process, unless they're getting the transcripts day by day and kind of highlight and maybe chronicle them or something, I can't imagine going over almost 2 years worth of transcripts to try to deal with an appellate, trying to file an appellate brief. That has to be a headache. Emergency relief is requested because the witness that was coerced by Glanville is presently on the witness stand. So Woody is still on the witness stand. Absent emergency relief from the court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding, but not provided to counsel as required by law. Brady material is material that is favorable to your client. So if the prosecution in their investigation, reviews, interviews, whatever, get any type of evidence, material, witness statements, anything that is favorable to your client, they are supposed to turn it over because it's considered Brady material. And it's called Brady because it's based on a case with the word Brady in it. That's how most of our names come from, like Miranda rights. That was what Arizona, Miranda versus Arizona, or Arizona versus, it's one of those. It's the in the case caption of the case, just for those of you that wonder where these names come from. And honestly, Brady material from a person that does or helps with wrongful convictions or helps with appeals, that is one of the most, those are one of the areas where you can get some play from. If they withheld evidence that was favorable to your client, you can get some action. Sometimes it's very, very hard when you say it wasn't, the evidence was insufficient or ineffective assistance. Those are a little rough unless it's like a drastic in your face type of error. But when it comes to you withholding evidence, that's the problem. So anyway, as well as the coercive joint efforts of the bench and the state, given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, cast a pall over any rulings that Glanville may take during counsel's cross-examination of Copeland. So this is the release. Sought as Glanville has found petitioner's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests this court grant a writ directing Glanville to adhere to Rule 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. So they want him, the relief they are requesting is that Glanville let some other judge do it. Because we're asking you to be removed. We're saying you're wrong. Do we really think that you're going to admit that you're wrong? So we need somebody unbiased who can look at all of our information, look at all of our briefs on both sides, and they can come with an unbiased opinion that they feel that Glanville can't give. Petitioner further asks of this court that proceedings in the trial and the case number be stayed pending the resolution of the motion for recusal. So they want the trial to actually be halted until the recusal motion is decided. Petitioner further asks this court for a writ ordering Glanville to produce immediately and certainly no later than prior to the start of cross-examination of Copeland an unredacted transcript to defendants of the secret ex parte proceeding held on June 12, 2024. Petitioner also seeks of the court that it enter any further writs or orders it deems appropriate given the actions of Glanville. Okay, let's go to the facts. So some of you guys may not know what actually happened, so let's get to the facts here. Hey, you guys, I see you guys coming in. Thank you guys for doing this late night court reading with me. I appreciate that. You said, child, I'm woe out America. Ooh, it's rough out here. If you was watching that debate, I talked about that at the beginning. It is rough. But I still believe. Okay, I want you guys to hit that like button on your way in. Let's go ahead. So let's get into the procedural history. In January 2023, nearly 18 months ago, trial began in Fulton County Superior Court in the state versus Diamante. I probably seen his name messed up. Kenrick et al. Jury selection took more than 10 months, with trial before the selected jury began November 2023. Following the secret ex parte proceeding on June 10, 2024, Petitioner filed and presented a motion to recuse an accompanying affidavit from Doug Weinstein, that is the lawyer on this here case, to Glanville on June 12, 2024. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and the violation of the judicial code of conduct that occurred during that secret proceeding. The motion was summarily denied instantaneously with a formal order issued on June 14th. The secret ex parte proceeding. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants, is Mr. Kenneth Copeland. So he's actually like one of the main guys apparently in this case. On Friday, June 7, 2024, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the fifth. He was like, I plead the fifth. They're like, you can't plead the fifth. You have immunity. I plead the fifth. I plead the fifth. That's how I was going. So then Copeland was held in contempt and ordered incarcerated by Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th, 2024 at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Unknown to any members of defense counsel, an ex parte proceeding was held in Glanville's chambers on June 10th, 2024. Among the attendees was Glanville ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Ms. Kayla Bumpus. No member of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase of the trial. Neither Glanville nor any member of court staff nor the Fulton County DA's office made any member of defense counsel aware of the ex parte proceeding either before, during, or after the proceeding. One or more members of the defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland though not from Glanville nor from the DA's office. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Glanville. So this is what is alleged to have happened in this secret ex parte meeting. You guys ready for it if you've never heard it before? Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. Upon information and belief, Copeland stated that he would rather sit in jail for 2 years than to testify. Upon information and belief, Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. So apparently these 6 is not it. Allegedly, there's going to be about a dozen more defendants that's going to end up standing trial for, I guess, related or their contributions to this alleged RICO. Upon information and belief, following the above coercive actions by Glanville, working in concert with the one or more attorneys from Fulton County DA's office, sworn witness Copeland stated at the ex parte proceeding that he would testify. Upon information and belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. So he's like, oh, okay. You gonna testify? Well, let me tell you what the consequence can be. Let me print out the perjury statute, perjury under Georgia law. So then he pressed print. Perjury came out. He's like, here you go, sir. And this is what happens if you do a false statement. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand Important Brady material that has yet to be provided to Kendrick. What? Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. Important Brady material that has yet to be provided to Kendrick. What? So allegedly, they said if you get up there and lie, we're not going to prosecute you, but we know you lying. And let me tell you something. Let me tell you what's so jacked up about that. The way prosecutors have absolute, and I ain't saying whether this happened or not, but the way they have absolute immunity, they can literally, they're supposed to, from an ethics standpoint, if you know someone is on the stand lying, you do like a sidebar typically, you let them know, like, listen, I'm letting you know this is not true what they're saying. However, if, for instance, it turns out the person lied, the prosecutor knows that they lied, and then the person ends up getting convicted and they're in prison. And so they get out and they want to file a civil lawsuit because they were wrongfully convicted or they were wrongfully held, unlawful imprisonment, wrongful arrest, no probable cause, all of that. The prosecutors have absolute immunity. So it's very difficult for them to even be punished from a civil standpoint. They don't just have qualified like police officers have. People talk about qualified immunity, but you got ways to get around qualified. But absolute immunity, as long as they're doing whatever they do, be it within the confines of the law, be it ethical, not whatever they do, as long as they are doing it in the course of their prosecution, they are immune. So even if that lie happens and they're sitting on the stand and you know as the prosecutor they're lying, the way absolute immunity works from a civil perspective. Now, that doesn't mean that, maybe some other stuff can happen from other, the bar or whatever. But from a civil perspective, if somebody wants to try to sue them because they find out this prosecutor knew this person was lying, or I had a situation where there's a prosecutor who allegedly prepped somebody to lie. If that happens, they got absolute immunity because they're doing it in the course of their employment as a prosecutor. Isn't that crazy? I just thought I'd tell y'all that. But that's from the civil standpoint. Anyway, upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he unalived Donovan Thomas Jr. Important Brady material. Yeah, that's very important. If he was going to say he the one that did it. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify that he unalived Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he unalived Thomas. Important Brady material that has yet to be provided to Kendrick. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to suppress or repress Brady material that should be provided to Kendrick. Attorney Kayla Bumpus, buying through her attorney, filed a motion to quash order to show cause and motion to recuse on Friday, June 14, 2024, which substantially supports the Weinstein affidavit. As a participant in the ex parte proceeding, Bumpus' firsthand account of the misconduct is credible. The facts attorney Bumpus asserts are as follows. So this is what Woody's attorney is saying that happened. On Monday, this is attorney Bumpus. She says on Monday, June 10th, 2024 at approximately 8:30 a.m., Mr. Copeland and his lawyer, attorney Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte proceeding regarding whether Mr. Copeland would testify. Those present for the substantive portion of the ex parte proceedings were Glanville, Copeland, attorney Bumpus, lawyers Love and Hilton, members of the court security staff and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. In chambers, Glanville asked Copeland whether he was prepared to testify. Copeland announced that he planned to reassert his Fifth Amendment privilege. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he would be held indefinitely by Glanville if he refused to testify, not just 2 years as he initially believed, Copeland yielded. Copeland cautioned that his testimony would be a lie. What? So apparently another officer of the court, Miss Bumpus, who was there, said that Copeland cautioned that his testimony was going to be like, I'm going to testify because you saying that I could be up in this jail indefinitely instead of the 2 years that I figured and counted in my mind. So I'm going to go ahead and get on the stand. Oh, but by the way, I'm going to lie. Events in court about the time of the secret ex parte proceeding. On Monday, June 10, 2024, all defense counsel were present in the Fulton County Courthouse at around 8:30, admitted interest into courtroom 1C, and seated within by 9 o'clock. Defense counsel waited and waited. Between 11 a.m. and 11:30, Glanville took the bench and announced that Copeland was prepared to testify. So basically, when the defense came in, they were told to be in the court within a certain amount of time. So they're in there by 9 o'clock and they're sitting there like, they don't know what's happening. They just sitting there, and then the judge takes the bench at 11 o'clock, 11:30-ish, and says, oh, we're ready to go. But there was no, the defense didn't know why, but apparently the why they learned because of this secret meeting. Sensing something amiss, attorney Brian Steele, on behalf of all defendants counsel, specifically asked Glanville about the reasons for delay, providing Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempt to discover a reason for the delay. So Steele was like, something ain't right. Like, why are we sitting here for 2 hours and like, what's going on? And so at that point, the judge could have said, well, we just had an ex parte meeting. We want to tell you what the meeting was about. He was just like, apparently, I guess the judge didn't say anything. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge this information, citing Rule 1.6 of the Rules of Professional Conduct, Glanville held Steele in criminal contempt and sentenced him to 20 days incarceration. Glanville's hearing on the motion to recuse in subsequent order. On June 12, 2024, Kendrick filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous rulings. Glanville ignored the subject matter of the motion affidavit, which was an accusation that the June 10, 2024 secret ex parte proceeding was, one, in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person, including defendants such as Kendrick, a fair hearing, and two, in violation of Rule 2.11a in the revised Georgia Code of Judicial Conduct that says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. During the June 12, 2024 hearing on the motion to recuse, Glanville refused to conduct the timely analysis required by USCR 25.3. Despite Weinstein bringing this to the court's attention, Glanville refused to make any findings and summarily denied the motion. He was just like, denied. Okay, thank you, sir. Okay, I read your motion. Everything is good. Thank you, sir. I'm going to deny your motion right now. Okay, is the jury ready to come out? That's how I read everything that you have, sir. Is the jury ready to come out? Denied. Jury ready to come out? Okay, let's prepare. Stand for the jury. Good morning, ladies and gentlemen. I hope you guys had a good rest. We're going to be here till about 2:30. Weinstein requested at that time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Glanville's ruling. Glanville stated that an appeals court could look at his denial at the conclusion of trial. So basically, Glanville is like, once we finish the trial, you can do all the appeals you want. Have it. You can have it. But I'm not going to give you access to an immediate appeal right now to appeal me. No. You're going to wait till all of this is over, and then you're going to read through all these transcripts, and then you're about to do an appeal when this is all over. And then it's an abuse of discretion standard anyway, which is a very high bar. So good luck with that. On June 14, 2024, Glanville issued an order on a motion to recuse Chief Judge Glanville attached as Exhibit B. The order formally denied the motion. In that order, the court did make findings, though not in the timely fashion required by USCR 25.3. The court found all three prongs of Rule 25.3 satisfied and that the analysis should have stopped there, and it got Exhibit B, but Glanville did not. Applying the wrong standard and reaching the wrong conclusion, Judge Glanville found that the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of their motion contains assertions of fact to support the allegations of bias and impartiality. However, while these assertions were made to support the defendant's allegations against Judge Glanville, there is a notable lack of evidence to support the assertions. This was the first of three motions to recuse denied by Glanville. So they just go through for the whole standard is when you're asking for a writ of mandamus, which is what they are doing. And they're alleging that Glanville has failed to follow the rules on recusal and has violated multiple rules of the Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. And then it has the Monday case as its authority. So they say Glanville failed to follow USCR 25.3 during the hearing of the motion to recuse on June 12, 2024. Glanville, following filing and presentment of the motion to recuse on June 12, 2024, failed to make the required determination under USCR 25.3. Glanville summarily denied the motion, relying on a mischaracterization of the Weinstein affidavit as a complaint about a ruling made by the court instead of recognizing that it has a list of incidents of judicial misconduct by Glanville. Glanville curiously clings to Baptiste v. State as supporting his contention that the Weinstein affidavit does not merit recusal, but there is no support in Baptiste for the proposition. In fact, Baptiste supports petitioner's position that Glanville's bias is of such a nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. They say Glanville failed to follow USCR 25.3 in his order. Okay, I'm not going to read that. Glanville failed to follow the proper procedures, requires referring a motion to recuse to an unbiased judge after the three prongs of 25.3 have been met. Glanville has violated multiple rules of the Georgia Code of Judicial Conduct. Let's see what they're alleging as the rules that they're saying that he violated. Chief Judge Glanville's secret ex parte proceeding violated at least USCR 4.1 and GA Code of Judicial Conduct 2.9 and 2.11a. The facts alleged in the Weinstein affidavit must be assumed true when deciding whether recusal will be warranted. The details learned by Weinstein include the holding of an improper ex parte proceeding conducted with sworn witness Copeland. This violates Kendrick's rights to due process and a fair trial. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person a fair hearing. Ex parte communications are presumed to have been in error, and that's in City of Pendergrass versus Skelton. Not only did Glanville fail to notify defense counsel about the ex parte proceeding as required by Rule 2.9, but Glanville made every effort to conceal the proceedings. As attorney Lester Tate states in paragraph 14 of his affidavit, In reviewing the video of the exchange between Judge Glanville and Attorney Steele, there was no disclosure of the ex parte proceedings, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Judge Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might already have disclosed. Georgia Code of Judicial Conduct Rule 2.11a says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. Furthermore, Chief Judge Glanville shall not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. And that's in Wynn v. State. That's a 76 case. They got Bitten v. State. That's a 1938. They done went back in the archives. They was like, that's kind of like with the Nesto case, how they went in, they got that bigamy charge. They was like, they went and found some cases from back when they first started making cases in the book. As this court wrote, we need not decide whether such bias and impartiality actually existed because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has a personal bias or prejudice concerning a party or a party's lawyer. That's in Johnson v. State. Defendants were not provided notice of the hearing. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. The only logical conclusion for the secret nature of the proceeding was to give Glanville, in conjunction with the state, the unfettered ability to harass and intimidate the sworn witness and to testify. The motion to recuse met all the requirements, and Chief Judge Glanville must assign the motion to recuse to another judge for consideration on the merits. Whew. Glanville's failing to follow USCR 25.3 violated at least Georgia Code of Judicial Conduct 2.1. Rule 2.1 of Georgia Code of Judicial Conduct reads that, quote, judges shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. In the hearing of June 12, 2024, Chief Judge Glanville failed to follow USCR 25.3 by failing to make the determination required in a timely fashion. Petitioner need not repeat the details of Glanville's actions here. Glanville's failure to follow the requirements of Rule 25, both on June 12th and June 14th, were a violation of Rule 2.1 of Georgia Code of Judicial Conduct. The conclusion: Glanville's actions offend public confidence in the independence, integrity, and impartiality of the judiciary. An appearance of impropriety and bias hangs over the present trial due to Glanville's failure to follow the law. As Attorney Tate writes in paragraph 15 of his affidavit in Exhibit C, here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing and who also has actively attempted to conceal the proceeding. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality, and assuming it to be true would require recusal. Again, I reached this conclusion based on Judge Glanville's actions, not only ruling that he has made in the course of the trial. So they must have got like I look to see who this person is, but it looked like they're kind of doing it in an expert. Their affidavit is kind of in an expert manner. Petitioner requests this court direct Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed by this court to assign the motion for recusal to an unbiased judge for hearing on the merits. Petitioner is further requesting a writ ordering Glanville to immediately produce an unredacted transcript to defendants of the secret ex parte proceeding. Petitioner further requests that proceedings in the trial be stayed pending resolution of the motion for recusal. Petitioner also requests this court enter any further writs or orders it deems appropriate given Glanville's action. And then they got Doug and Jay and the ABT law firm and The Hingardy law firm. They got a few lawyers on here. So they got the motion that's attached. That was Exhibit A that he was talking about. Let's see. This is Weinstein's affidavit that he kept referring to. Then this is the judge's order on the motion to recuse, where he basically said, hereby denied. Denied. So that was the order. Lester Tate. He says, I am over the age of 18 years. I make this sworn testimony under oath. I am suffering from no legal disabilities, and I am competent to make this affidavit. Said affidavit being based on my personal knowledge of the facts herein after set forth, and I make this affidavit for all legal purposes. I'm the owner of the Cartersville-based law firm Lester Tate Law Group, Akin and Tate. As to my experience and qualifications, I show the court the following. I am a trial lawyer of 36 years and served as the 48th president of the State Bar of Georgia. I hold a bachelor's degree from the Georgia Institute of Technology and a law degree from the University of South Carolina. I have spent my entire professional career as a courtroom lawyer, having tried over 100 civil and criminal cases to verdict. Okay. I have been inducted into the American Board of Trial Advocates, one of the nation's most prestigious trial lawyer organizations, with the rank of, quote, advocate because of my extensive courtroom experience. I have previously served as the president of the Southeastern chapter of the American Board of Trial Advocates, president of the Georgia chapter of ABOTA, and national treasurer of ABOTA. Additionally, I am a fellow of the International Society of Barristers, the International Academy of Trial Lawyers, and a senior fellow of Litigation Council of America. Okay. I am licensed to practice law in Georgia and admitted to practice in a number of courts, including the Supreme Court of the United States, the 11th Circuit Court of Appeals, the U.S. District Court for the Northern and Middle District of Georgia, and all Georgia state courts. I have been admitted pro hoc vice in other jurisdictions and have never been subject to any disciplinary action by any state bar concerning my provision of legal services in any courts. I served as a member, vice chair, and chair of the Georgia Judicial Qualification Commission between the years of 2012 and 2016. Since 2016, I have regularly represented and advised Georgia judges from all classes of courts in cases involving judicial ethics and the application of the Code of Judicial Conduct to their service. Accordingly, I have developed a particular level of expertise with all aspects of the Code of Judicial Conduct, including provisions which relate to ex parte communications. Okay, so yeah, like I said, he was hired to be an expert. Okay, Mr. Tate, you better let us know you about that life. He said, I've done this, this, and that. Okay. Then this is Miss Bumpus. She did a motion to quash the subpoena for her to come to the show cause. And is that who did this one? Okay. All right, gang. So that is, I know it took a minute, but I wanted you guys to be thoroughly knowledgeable, because what the Supreme Court said wouldn't even make sense if you don't even know what the motion is about. Eve said Glanville should hire Lester Tate. He all that and then some. Listen, he put in work. I'm like, okay. Shoot. Shout out to you, Tate Esquire. Right. Said Judge Glanville, like, denied. Who gonna check me, boo? That basically, this is my world. You see this? You see this courtroom? He probably is like, look to your left. Okay, now I'm directing all counsel to look to the right. Now I'm directing all counsel, turn around and look behind you. And I want you to look straight ahead. This is my world. You guys are sitting here in my world. Because he straight up was like, denied. Denied, denied, denied. Okay. It's almost 800 of you guys in here. Make sure you hit that like button. So this came down today, of which Weinstein posted it on his page. Doug Weinstein's on his Twitter game today, and he posted this on his page. And this is what the Supreme Court had to say about all that we read. Did it in 3 good pages. They said petitioner Diamante Kendrick, who is facing trial on unaliving and other charges in Fulton County, filed directly in this court an emergency motion seeking original relief in the form of mandamus against Chief Judge Glanville and a stay of proceedings. Kendrick filed in the Superior Court a motion to recuse Chief Judge Glanville after he became aware of an alleged ex parte meeting on June 12, 2024 between the judge, assistant DA, a state's witness, and the witness's attorney. Chief Judge Glanville did not refer Kendrick's motion to recuse to another judge, see Uniform Superior Court Rule 25.3, and instead decided the motion himself and denied it. So then the court actually puts the rule of USCR 25.3, which provides when a trial judge is presented with the motion to recuse or disqualified, accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination, assuming any of the facts alleged in the affidavit to be true, whether recusal would be warranted. If it is found that the motion is timely, the affidavit sufficient, and that recusal would be authorized if some or all of the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. Ooh. So as I read in the motion, the judge actually said that all of the prongs were met, as Weinstein said. Those prongs were met, that the judge did, and I did watch that hearing. The judge did make a determination that the motion was timely. He also said that the affidavit was sufficient and that assuming the facts alleged in the affidavit were true, recusal would be warranted if it was true. So according to this rule, it should have went to another judge. So the allegations of the motion shall stand denied automatically. The trial judge shall not otherwise oppose the motion, and reviewing a motion to recuse a judge shall be guided by Canon 3E of Georgia Code of Judicial Conduct. Okay. In his emergency motion, Kendrick does not seek appellate review of the order denying his motion to recuse. Instead, he seeks original relief from the court against Chief Judge. So he's filing it for the first time in the Supreme Court, when really the Supreme Court is a court of appellate relief. Usually it's after you go to the Court of Appeals, then you go to the state Supreme Court. So they're not like the trial court presents the original case. So what he's doing is presenting this motion to the Supreme Court originally, and the reasoning is because they filed mandamuses and they filed other, I think they said 2 writs already with the court, and they haven't gotten any responses, and they feel like if they file anything with the court, it's just going to go there to die. That was in his words. Said it won't be heard and it's just going to be there. Then we got to wait until after the trial is over and all of that. So he did it on an emergency basis, asking the Georgia court, Supreme Court, can they please step in? It's like, please help us out. Instead, he seeks original relief from the court against Chief Judge Glanville, asserting that any efforts to file a petition for writ of mandamus in Superior Court would result in frustration and lack of action. Quote, because such a petition, quote, will go to Chief Judge Glanville, end quote, And so he, quote, has no option other than for the Georgia Supreme Court to exercise its discretion and consider his claims, end quote. By way of relief, Kendrick requests that this court direct Chief Judge Glanville to adhere to Georgia Uniform Superior Court Rule 25.3 and assign his motion to recuse to an unbiased judge for a hearing, that the court stay the trial proceeding pending resolution of the motion to recuse, and that the court order Chief Judge Glanville to produce an unredacted transcript of the secret ex parte proceeding held on June 12, 2024. So when you do a writ of mandamus, is basically what they're saying is that you're trying to direct and order the trial court to do something. You're asking them, if since they don't listen to me, you think, big brother, you think you can tell them over in the trial court what they need to be doing? Thank you. Although the court has the power to grant original relief in the nature of mandamus, see Georgia Constitution 1983, Article 6, Section 1, Paragraph 4. It has chosen to maintain its general status as an appellate court and to exercise its original jurisdiction only in extremely rare situations where need has been shown, and that's Graham v. Cavender. And before this court will consider exercising its original jurisdiction, the petitioner must show that he has sought and been denied access to the proper channels for seeking relief in a trial court. See Gay v. Owens, which stands for the proposition that original jurisdiction exercised only in extremely rare cases. Brown v. Johnson stands for the same proposition. Kitchen v. State stands for the proposition that Supreme Court is a court for the correction of errors of law committed in the trial court. Moreover, it is well established that a petitioner seeking mandamus relief against a superior court judge may file such a petition, quote, in the appropriate superior court, end quote. And, quote, being the respondent, the superior court judge will disqualify another superior court judge will be appointed to hear and determine the matter, and the final decision may be appealed to the appropriate appellate court for review. Basically, the Supreme Court is, this is what you need to do, Mr. Weinstein. This is the step, this is the pathway to get to where you're trying to go. This is the pathway. File a petition. If they see the judge's name on there, then it should automatically go to another judge because that judge's name is on there. Here, before seeking original mandamus relief from this court, Kendrick is required to show that he first sought and was denied access to the proper channels for seeking relief in superior court, and Kendrick has not made such a showing. As he admits that he has not filed a standalone mandamus petition against Chief Judge Glanville in superior court, although Kendrick expresses concern that filing a mandamus petition in superior court would be futile because the petition would be assigned to Chief Judge Glanville, that is not so. Y'all hear that? So if this petition for mandamus was filed in superior court, if it was against the judge according to the Supreme Court, they're saying it's not going to go to Glanville. So you filing this with us first was not appropriate. We are a court of review, of appellate. We review what the trial court does. So you got to follow the proper channels. And we're letting you know that if you file this according to the law, it is not going to go to Glanville. As explained in Brown, if Kendrick were to file a mandamus petition in superior court naming Chief Judge Glanville as the respondent, Chief Judge Glanville would be disqualified from presiding over the matter. A different judge will consider Kendrick's petition, and either party may appeal the final decision. And that's Brown, the Brown case. Accordingly, Kendrick's emergency petition for writ of mandamus and stay of proceeding is dismissed. So that is why that got dismissed. But the Supreme Court told them, like, what you filed with us, you just filed in the superior court, and they're supposed to be disqualified. But if you don't like what this judge that's going to be assigned this petition, you don't like what this judge has to say, then you appeal. because we are not original jurisdiction unless it is an emergency, which this is not. So that's that. Auntie Eva said he skipped a step or two. He did. But I think what happened was because they had filed motions prior, again, they filed writs prior. And again, it wasn't against the judge. Like they were trying to get property or something, according to what they said. They felt like if a mandamus was filed, the judge would just ignore it. But they didn't know it wasn't going to go to him as the chief judge if his name was on there, is what it sounds like. So the Supreme Court gave them a little direction and said, if it doesn't work out for you there, then you can appeal. Have a good day. Dismissed. You get it? Okay, I'm glad. It's her rocks. Said, oh, okay, I understand now. Yes, for always forever for life said, OMG, Pam, I didn't know you were gonna be live. I just finished watching the debate. Yeah, I watched it up until I think it was supposed to be 90 minutes, so I watched a good 60 of it. I did a little bit of commentary in the beginning. Yeah, that makes sense. Thanks for the breakdown. Thank you, Kelly, for watching. Cherie Nicole said when going above you goes wrong, he better log on e-file and submit all that to the right court. I done did it tonight. So yeah, so then Weinstein, like I said, he is the one that posted this. And when he was on, this is what he had on Twitter. The Supreme Court of Georgia has denied Mr. Kendrick's petition for writ of mandamus based on a requirement that we must first petition Fulton County Superior Court. Court notes that the petition must be heard by a judge other than CJ Glanville. We are not done seeking relief. So he said he will be fighting on. This is yet but a bump in the road. See, he has note the portion that the Supreme Court of Georgia emphasized if it is found the motion is timely, the affidavit is sufficient, and that recusal would be authorized if some or all of the facts set forth in the affidavit are true. Another judge shall be assigned to hear the motion to recuse. That is true. The court did emphasize that part. So it was almost like they were telling them, you're right about he's probably supposed to recuse himself. We're not saying you're wrong. We're just saying from a procedure standpoint, you didn't do this properly. So we just gonna need you to do it right, because we don't think this is an emergency. This is something that you could have filed. Yeah, he may have, you don't know. They basically advised him he would not, if his name is on that document, which makes sense. Like, I don't understand how Chief Glanville's name could be on the caption and he get the case. That doesn't even make any sense to me, and I don't even have to look at a rule. That's clearly a conflict. So yeah, I think they did that to get that little note because I know Glanville would have taken it. You think so? You think Glanville would have took it anyway? That's interesting. But yeah, he's talking about down here when he talks about this, they italicize part of this, which is emphasis added, because that's not how this USCR 25.3 is written. So the judge did emphasize if it is found the motion is timely, the affidavit sufficient, and that recusal would be authorized if some or all the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. So the Supreme Court, they italicized that. So I think they're kind of throwing Glanville to let him know, yeah, you might have got this wrong, buddy. Because Glanville did say on the bench that all of those prongs were met. So therefore, he should have recused himself of this hearing that's coming up. Now, Glanville did, and I posted that on the wall. The date was moved because it's supposed to be an in-camera review. What an in-camera review is, basically you're back in the judge's chambers and it's not a redacted document, and you get a chance to look at it, and you'll see what should be what should be redacted, what shouldn't be redacted. So it's supposed to be an in-camera review, and I guess they're all going to get transcripts. But somebody said the transcripts are supposed to be redacted, but I think it's probably going to be redacted after they all look and see the in-camera review. So they'll have knowledge of what it would be unredacted, I presume, but for purposes of you getting it in your hand, it's going to be redacted, because that'll be what you use when you file motions and attach it to your motions, which we as the public will see. And then the original, the judge said it will be in a sealed envelope, so it'll be under seal. Todd Glass said, I don't like the fact that recusals go to the judge to recuse themselves. That's dumb. It's very dumb. But apparently, if all the prongs under the rule are met, then it's not supposed to. It's supposed to go to another judge, which makes more sense, because you come to me and so, but so I had, let me tell you my recusal story. I've never tried to recuse a judge, but I was doing a divorce case one time, and the guy, I don't know how long I was practicing. It might have been 2 or 3 years, because it ended up going to trial. In divorce cases, when I did family law, I used to settle, but it ended up going to trial. But it was a guy, and he had been in the game for a minute. So when he seen me come in, and I guess I was looking all young, he was like, "You look like you just graduated from law school." I'm like, "It's what we doing?" So he was trying to intimidate me or whatever. So it ends up going to trial, and he wanted to postpone one of the days. He wanted to postpone one of the days, and it was something else. It was 2 motions he did that I won. And so he filed a motion to recuse the judge and said the judge was biased. I'm like, based on what? Because I got the laws on my side. Like, what are you talking about? So he ended up doing that. And when he did the motion for recusal, it went to our chief. It was a regular sitting judge that was over our case, but we had to argue it in front of the chief judge. He didn't argue it. That judge didn't decide that. We went to the chief judge of the court. We had to go to his courtroom, and that's pretty much all he did at that point. He was an older guy. And we went and we argued. I mean, he lost because there wasn't really no reason, but he tried to make it seem, I guess in his mind, the only way I could be winning like I was doing, because I was winning. The only way I could be winning was because this judge just likes me like that, because it didn't make no sense. Like, he had been practicing 1,000 years and I had been practicing 4,000 minutes, you know? So it was like, get the judge off the bench. There is no way this chick should be beating me right now. Something is wrong. So, yeah, but we had to go right in front of the chief judge. But that was the only time, because like one case I had recently, it was against a school, and the school that I was suing, the court that I was in, it was a very popular school for like politicians, kids, and all of that. And so a lot of people on the bench, almost the whole bench, somehow was affiliated. Like, either they went to the school, or their brother went to the school, or their nephew went to the school, whatever. But the judge, I pulled a woman, and it was an all-boys school that I went against, but I pulled a woman, and her nephew like currently went to the school. So she told me, like, I just wanted to let you know it's not going to affect how I am as a judge, but I do want to disclose that I do have a nephew that goes to this school. I feel like I can be unbiased. I don't really care one way or another, but if you want me off the bench, that's cool. We can assign it to somebody else. I was like, no, because I knew whoever it was assigned to, unless we changed jurisdiction, they probably went to school too, because it was basically males on the bench, and it was an all-male school that I ended up having a case against. So I think it's strange that I think that ethically, a lot of times, just from an ethics standpoint, which is something Weinstein brought up, is that if you think that there's a look of impropriety, that you might want to just step down. And it just seems like with Glanville, he's adamant on being right, I guess. But from the outside looking in, again, the way the rules are looking and all of that, it looks like that ex parte meeting, in my opinion, it seems like it shouldn't have happened. Seems like it was an issue. And the fact that all of this is because you want to make someone tell you who said it, that's not making sense to me. So perhaps I'm missing something. Maybe he has some law somewhere that I don't know about because I don't practice in Georgia. It may be different. So I'm gonna be watching it because I think this is an interesting situation that's happening. But I think at this point, because so much time and resource has been wasted, and then you have these jurors that have been sitting forever, what would you feel like if you're a juror, you not making any money for real that you can live off of? You're coming here every day for like a year. You've literally sacrificed to be on this bench. I mean, to be on this jury and to help render this verdict, and turn around and it's just a mistrial. So everything just you probably wouldn't be happy either. So I think he's trying his best to just preserve this case to the end, knowing it's probably some appellate issues that they're going to deal with and all of that. But I think at this point, he's just trying to make it to the end. That's it. Auntie even said I would quit that jury. It was with a sworn witness. The ex parte had no notification to the defense. Yes. This judge is also running for re-election this year. Oh my. Dark and Lovely said he's very arrogant and stubborn. Miss Love can sit down. Glanville can prosecute this case by himself and his service. Eve. I seen a whole video that they did on his service dog and all of that stuff too. It's interesting. I've seen service dogs, like I've had trials with, well, I had a trial where kids were involved. And so the kids that had to come testify, they had a service dog that came in that met them at the door and all of that. But how do I feel about a lower judge hearing this recusal of the chief judge? That's insane to me as well. Like, how can a lower judge grant a recusal of chief judge, or are they equal? Judges are the chief judge is just I mean, they should all do their cases the same. I mean, you just have more responsibility because you're the overseer as the chief judge. But if you're talking about the law is what it is, and if you apply the law to the facts, it shouldn't matter what level you are in the court. I mean, you're just applying the law to the facts. And it looks like they went to a expert, like who we pulled up tape. They went to an expert to make sure that their interpretation of what the law is, the statute, and what ex parte communications and what that entails. They went and got someone to basically validate their interpretation, or they may have went to them first before they even filed the motion to make sure that it was accurate. So let's see. That man had no intention on recusing himself. He is dirty, and it shows. He is pro-prosecution. Defense had to take severe Had some very good defense attorneys. Very, very good. And you know what? What was interesting to me, like watching DA Love and the stuff that she was doing and how she was like pressing and wouldn't be quiet when the judge said it, and how she was pushing and just pushing till she got her way. And little things like, I think it was one early on, she used I think it might have been a PowerPoint, and it had information on there that they had already done a motion that had to be excluded. Like little things that were being done. And all I could think of is, if you have an overworked court appointed, they probably would get away with a whole lot of stuff. It's just you're dealing with defendants with a couple of dollars. I think maybe one of them may have a court appointed, one or two maybe. But for the most part, you're dealing, even those one or two, they're kind of sitting off in the wind because you do have still, you have Weinstein, you have all these big firms that are known to represent these rappers or stars or celebrities, and so they're getting, heck, they getting paid to do what they're doing. They fighting every inch of it. They're not giving anything away. They're fighting everything. That record is going to be full of objections, full of motions, full of all of this. Like, they preserved the record very well to go on appeal. So shout out to them. But all I kept thinking was, if you get a newly person off the bar who doesn't really know the tactics or whatnot, and they just come on and they're representing someone, how much have they gotten away with these type of tactics? The woman, I got a job. Thanks for the update. It's very interesting how it's shaping up. Good night, intellects. Thank you so much, the woman he chose. I appreciate it. Pam, is it common for cases like this to go on this long? I had the longest case I had was like a 3-month trial, and it was like 5 defendants. And I thought it was too long because I felt like it could have been longer because we were starting so late and we was ending early and all of that. So that's not my experience. I think they slated this as being the longest trial, that it's going to end up being the longest trial in the history of Georgia. That's what they're calling it. So this is going to be something new. So no. Eve says Supreme Court threw Weinstein good bone because Glanville's bringing Georgia into disrepute. Yep. And I know you guys did see that our good sis Christina, former Judge Christina, was thrown off the bench. So I don't know. We may have to go over all of her counts because that was crazy. Her misconducts, I didn't really know. I heard about her being declared incompetent and all of that stuff, deemed incompetent or recommended, whatever, on the bench, pertaining to the bench. But I didn't really get into it until I was reading up on her stuff, and I was like, oh my gosh, yeah. It is. Pam, do you think the feds will come and investigate the judicial system, the officers of the DA's office? Do you think there's something, you think it's something going on with the DA's office? Because the only thing I really heard, like, statutorily wise, when I first started covering the Nesto case, I was the first one. It didn't make sense to me that he was sitting in there unindicted. First, I didn't even understand we don't do that indictment system like that here. We do it where you have a preliminary examination, the judge decides it's probable cause, and you get bound over. That's how it is. In Georgia, apparently, when it comes to felonies, a preliminary examination is almost just par for the course. It's like routine, but doesn't really have any real teeth. You find out what the accusation is against you, but that's pretty much it. But they have to, with certain crimes, they have to go before a grand jury and they get an indictment. So, but pursuant to statute, they have a certain amount of time that they can indict you. So that's really, they are within the confines of their law, where they got 4 years to indict based on a felony and a certain amount, a year or two when it comes to a misdemeanor. So they were within their law. Now, what they do, I think, to curb that seeming unfair is that they do the bond where after 90 days they must give you a bond. Like, it's a shall. So it's not an option. Now, but again, the bond can be, we give you a bond knowing you ain't worked since you've been sitting in here for a year and a half. So we'll give you a bond where sometimes they'll give you a bond where it's comparable to being no bond. Because if you give somebody $1 million bond and they don't have the money to pay for it, that's like you not giving them a bond at all. So those type of things, I think, I don't know. I still don't see the fairness of it. I think that they bring it, they being the ADA brings it before the grand jury when they're prepared to when they're prepared to try it. And I think the reason for that is because a person such as you hear Ernest say all the time, I want a speedy trial. He been saying that before he was indicted. So once they ask for a speedy trial, you have to put them up on the list, and within weeks, you have to try the case. And so I think what it forces the DA to do, the ADA office to do, is they don't even try to indict you until they know they're ready to actually try the case. So when you had, even with the RICO stuff with Nesto, when the judge asked about, well, how long would you need for the trial? It was basically ADA Wooten was like, oh, we can try this mug in a couple of months. But he's been sitting with all this information for the last couple of years. But Nesto's attorney now is the defense attorney. You got to catch up. So that's off to me. Then there's also an issue where I guess the chief judge is supposed to be notified whenever someone has been in for a certain amount, 90 days or a certain amount of unindicted. I think the chief judge is supposed to be notified, and that's some remedy they have to stop all of these people sitting in there, and they haven't been enforcing it. So I think that's an issue they're going to have to deal with. Madam DA claims in an interview that a lot of this is inherited. And because it's inherited, she's trying to fix it, which does happen. Sometimes you do inherit stuff. Then that's separate and apart from what you deal with all of the shenanigans with the jail on Rice Street. So I do think they have a lot of issues, but I wouldn't blame Fonnie Willis for everything. I think she probably did inherit some of this stuff, and now you have to dig through it. I'm sure they're short on ADAs. I'm sure they're short on public defenders. That's almost in every state because they don't pay like that. And then you have more people that can't afford an attorney than can. A lot of people are criminals because of what? They stole stuff because they can't afford it. You know, you got there. It's a reason why they're criminals. So they obviously don't have money to pay an attorney. So now you got overworked and you got you're spread thin and all of that. So it's a lot into it. So I don't know about having some big investigation unless there's evidence of just all type of corruption and impropriety going on. We're just watching what's happening with the YSL case. And then when you deal with Trump, now I believe that it was bad judgment to have someone that you're messing with and you're doing to be your special prosecutor getting paid, even though we know there was evidence. We went over video over here of some of the stuff that's alleged that Trump and his whole enterprise were engaged in, and all those other co-defendants. I'm sure it had nothing to do with I want to get my man a salary, because the guy, I mean, he had his own firm. He had been practicing and he had been special prosecutor before, I think, in Cobb County. So, but it was the look of it, and I don't think that was very, it wasn't the wisest thing to do. I'm sure she learned from it, but do I think that is enough to say, oh, the whole office is corrupt because of that? No, I don't think that. I don't believe that. You said, Pam, can you explain why laws are different in different states? Because so we all have different legislative branches which create the laws. We all have different courts depending on, that's why you deal with conservative and you deal with liberal. So you got cases like Georgia still has the death penalty. You have some like Michigan that threw it out. Like it's all about who you choose to be your representative in your state, because they help shape it. When it comes to the state side, now when you have the federal is what it is, and the United States Supreme Court trumps everything. And so every state, as long as the federal law hasn't preempted it, meaning they haven't taken over that area, the states have leeway to run their states how they want to. So you're going to have different laws at different places depending on. That's why when you see how some states didn't want abortion, but you got some that want abortion. You have the more liberal states that's what they want. Then you have some of the conservative states that's not what they want. You got some states that are into GUNs and open carry, and that you ain't got to have a CPL. It's a county, I think they have a county, I don't know if it's Georgia or Florida. It might be Georgia, where everybody has to have a CP, like everybody has to carry. That's what's in their in their sector there. So that's why you're going to have, and that's why they want you to take bars in every state, because a lot of the laws differ. Not all of them. You have a lot of similarities as well, but many laws are different. So that's one thing this has done with me doing this on YouTube, is for me to present it to you. I have to read their statutes and I have to read how they do things. So I always give the disclaimer that I'm in Michigan and I know that Michigan is different. Georgia is very different. I remember when me and Dev used to have conversations and he used to talk about New Jersey. I'm like, that don't make sense. And he's like, people don't move like Michigan. Michigan really tries to help you for the most part. So like they have random amnesty programs, like they have one now. If you got warrants, don't worry about it. Just come in and we'll handle your warrants. You owe child support? Okay, come in. We're gonna drop your warrants today, and we're gonna do this. They have officers within our district court in Detroit 36th district, where they have a floor where if you got warrants for tickets and all of that, they'll have random stuff where they'll like 50% off, almost like you having a sale. But I know other states don't do that. I've made crazy deals here that I know other states probably would say, like, they let you do that. So it's just every state is different. Travel Girl said that's why it's so important to vote in every election, not just the presidency. Your state is very important. And that's the same thing with these judges. Judges are elected. The majority of them are elected. You have some that are appointed, some that from the state side, some that are appointed, some that fill positions and all of that. There's always exceptions to the general rule, but it seems like people will fight really hard to get your vote to be a judge on the bench. You're going to get all type of flyers and circulars. You're going to get invited to meet your judge and all of that. But once they get on the bench, usually when they're incumbent, like once they're on the bench, if you were in front of that judge and you felt like they were unfair, or they're targeting Black people, or they have to come up for re-election. Stop making it so easy for them. Like, I think people just don't, when it comes to their local politicians, they just don't pay much attention to it. Like, why are people that judge over there in a small town, they're racist? Okay, well, why y'all keep voting them in then? You have the power to pull it together and say, I don't want this person. And maybe you will send a message that just because you get on the bench don't mean we'll let you stay on the bench. But most of the time, once you get in, you're not, people don't run against, a lot of times they don't run against incumbents. So, but you just have to that's part of the problem though. Like, people just don't take this stuff seriously. No, we have judges that are elected. In our state courts, they're elected for the most part. They get appointed to fill positions, or of course federal is appointed. That's why I said from the state side, federal is appointed by the president of the United States of America. They have a lifetime tenure. That's the lick job right there, becoming a federal judge. Next said, come to California. And do what? What am I going to do there? Cost of living is high. I come there and visit. I was there for Tory Lanez. I stayed there we stayed there for 2-3 weeks. I have a brother in California. I like California, but I don't know. I want to retire one day. It's expensive. Yeah. In California, I like some of their laws and how they do things. Some of them. I've learned some things on California as well with some of the cases that I've done. And we should go to town hall meetings too. Yep, I go to my little local city hall meetings. Judge Peterson still doing interviews. Is she? Where's she doing an interview at? Let me see. Let's see what Judge Peterson talking about. I don't see. She did it on a podcast or something. Maybe she did it on a. Did she do it on a podcast? Thank you so much for the Cash App. I appreciate it. Vanessa, I appreciate you. Thank you. Florida is a whole different. Florida is, see, a lot of times my contact with other states are people that leave that state and come here, or vice versa, or whatever. And when it comes to Florida, like divorces and family law, it's just weird. Everything is so weird. Everybody has the hardest times. But Georgia is like that too. I've had some people here where Georgia have made some crazy rulings that they just allowed a party living in Georgia to just file stuff. The other party doesn't even know it was filed. And now you lost custody of your kid. I mean, it's some weird things between Georgia and Florida when it comes to family law that I'm like, this is crazy. But yeah, and Florida is Florida and California, they make you sit for their bar. It's no reciprocity. They don't care how long you've been practicing. But like Georgia, I can have reciprocity with Georgia, Ohio, Illinois. If I wanted to waive into their bar because I've been practicing long enough, I can waive into their bar, pay their fee, as long as I pass character and fitness, of course. But it's like some of those, they'll let you waive into their bar and you don't have to sit for it. But Florida and California, they want you to sit for their bar. They don't got reciprocity with anybody. You want to practice here, you're going to sit here and take this good bar. That's what you're going to. I think New York makes you take their bar too. But I know for sure Florida and California does. Shay said people could just steal people property in Georgia. I don't know. They have some very different. I'm starting to learn so much about them that it almost doesn't make sense not to just go ahead and start doing some work there. But yeah, it's different. But anyway, guys, I'm gonna come on tomorrow. I think I'm gonna talk about Nesto tomorrow. Something else I missed with Erica. That I missed with Erica. I think I'm gonna talk about tomorrow. So hopefully meet me back here on tomorrow. You said I love my city, Charlotte, but the state a little shaky to me. North Carolina. Have I had any cases in North Carolina or South Carolina? I think I had a case in North Carolina before. I haven't had anything in South Carolina. You're in West LA. Okay. Thank you guys so much for hanging out with me to go over this YSL shenanigans. Last one. The state is saying maybe 150 more witnesses. Where are they going with this? With the line of questions to prove RICO, they seem all over the place. Yeah, I think that they should have probably, if you have a case against Jeffrey Williams, do the case. It's this whole RICO thing with doing 5 defendants or 6 defendants at one time. It just complicates things. You're going to have some things that are related to one person and not the other person. These witnesses aren't cooperative at all. They just sit there and they're like you got this witness Woody basically saying I'm a lie, allegedly. That's supposed to be what happened in a secret meeting. You had the first guy say, "Oh, I'm so high." So he said he was high. You had a young lady who was in the videos. They were talking about don't show her face. So the whole time she testifying, they not showing her face. But then they put the video up on the video she was in, and the judge is like, "Go ahead and show it." I'm like, what? See, that's the type of stuff that would make people not want to testify. Like, how you show a whole video to the public of who she is, but the camera couldn't be on her while she testifying to conceal her identity. And then she alleged that one of the investigators was trying to kick it with her. It was just, this has been the most dramatic, drama-filled case ever. And 150 witnesses is no joke. Can he legally deny all this if he is a witness? Isn't it a conflict of interest? They said he's the highest judge. I only watch Law and Order and you. I'm confused. Well, Nash, I hope I answered your question. I'm sorry I got to your super chat late. But the Supreme Court helped them out and told them what they needed to do. Jalecia says she's never seen a more unfair trial. Well, we shall see, guys. We shall see. All right, you guys have a good night. It's midnight. I didn't even know it was this late. Oh my gosh. That's what I get for starting at like 10:15. Make sure you like and subscribe to the video if you guys enjoyed it. If you did not, act like you did, okay? Because I've been up till midnight. But I'm going to talk to you guys later. You guys have a great night.